Thank you very much once again. Let me take this opportunity to welcome you back at this meritocratic channel and ensure you are sharing to those who are concerned. And then today we are going to look into and then also moving also in the exam questions pertaining or which they can be expected in the examination with regards to the memorandum. And then we are saying that today we are going to look and discuss module 5, whereby we're talking about the hierarchy of authorities. Ensure that you are referring back to our previous video, which we have posted before. And then when we are talking about the hierarchy, we are talking about the steps, whereby in a work organization chart, we've got the first as a CEO, which is the person that is above the board, the CEO and all the departmental managers up until to the cleaners. So we are saying that these different personnel, they carry different authorities, and authorities is the power that is invested in them, and then that is given to them. Without any wasting any time, one key concept that we should understand when we are dealing in these regards, after we are studying this module, we are to see that we will see or we will be able to discuss here in module 5 would show the background and the knowledge on the function of the establishment and the period of the interim government and the constitution. Please bear in mind that these personnel, they must act, they must do their job, which is the function, and then they must be established for a period of time, which is an interim. An interim basis, it does not mean a permanent base, it means a temporary base. We are saying in this overview, it is governed by the constitution, as we know that the constitution is the supreme law of the authority of the state. And then let us understand that in the second aspect, we are to explain the central authority schematically. And then the third aspect, explain the duration of the and the composition of parliament. So when we are talking about composition, we are saying in the parliament, we've got the president as the head, the deputy president as the second in command. And then we talk about that it can be a composition of parliament in that regards, or we are saying that in the parliament, we've got different parties which must, and then let us discuss now the composition and the qualification of the membership and the setting of the National Assembly. Remember, I've said to you, the word composition, it is who is there. So we must understand that, and then they must ensure that they sit in the National Assembly. Remember that in the National Assembly, we've got not more than 360 seats, the voters in the national voting system. And then we are saying that describe the composition and the qualification and the seating of the Senate. And the Senate is the board. This one is the council of the board. And then we are saying explain the joint function of the parliament and the Senate. So we are seeing that the key word is the joint. So joint committee, it brings back together this committee of parliament and this committee of Senate to committee, which will entail there is a living in the particular jurisdiction. And then we've got to understand that we must also explain the provincial authority schematically, the composition and the function of the provincial government, and the composition and the function and the qualification of the council, as well as the election of the premiers. So remember that premiers, they are the head of the province. So we want them to be elected, and how are they appointed in that particular position? Explain the institution and the status of the municipality, as well as the executive committee. And then we are here to explain the institution and the activities of the provincial council of traditional leaders. Remember, we are still talking about the traditional leaders. So we are saying that this happened in an informal settlement, and then explain the institution and the functions of the Volksstadt Council. So that is what we are going to learn. Tune on for more again in this content coverage. All right. Without any wasting time, let us dive into the content we must deliver today. Tune on up until to the next, the last now of the question. All right. If we are here, we are to see now the first question that can arise there. It says the threefold division of authority of the state should fulfill certain requirements in the democratic state. Remember, South Africa is a democratic state. Why do we say that? They've got their own border, their own population, and they are independent. That is the main function. And then we are saying the question, it says, briefly explain three authorities of the state. All right. And then these are the three authorities: the legislative authority, number one, executive authority, number two, and the judicial authority, which is number three. Then the main reason for the three authorities division is to ensure, protect, and to guarantee the freedom of the citizens and to prevent tyranny and autocratic government. When we are talking about the autocratic government, we mean that the government does not care of the people's opinion. They just take their decisions on their behalves. And then let us understand that the separation of powers in the sense of the free and the constitutional government authorities, they are named before. And then we are saying for legislative authorities, they design or they deal with the legislation. They are doing the executive, administrative. They establish and enact law in terms of the measure. That is for 6 marks. All right. And then I want us to move on to the second question. And it says now, state 3 aims of the current constitution of South Africa. Keyword, constitution. What is a constitution? This is the supreme law which governs the country. It has all the laws and legislations in the country. And then the aim, it is to heal the division of the past and create a society based on the democratic values, social justice, and basic human rights. Number 2, to lay the foundation of the democratic state, an open society in which government is based on the will of the people and the citizens are equally protected by the law. So we are saying that the rule of law, it states that all citizens are equal before the law. Even the state president is not above the law. And then its basic aim, it is to improve the quality of life of all citizens and free the potential of all people. Number 4, it is to build a united, democratic South Africa, able to take its rightful place in a sovereign state in the family of nation. It is for 8 marks. Number 3, to accommodate traditional authorities. Remember, these traditional authorities, they practice now these customs. So we are saying that they must be authorized by the of the House of Traditional Leaders. So we are saying whatever they practice, it must be in correlation with the Constitution. That is what we mean. So we are saying it is constituted from the representatives elected or nominated by the traditional communities in the provinces. So we are saying that different provinces, they've got different traditional leaders council. And in 3.1, briefly explain the compilation of the Provincial House of Traditional Leaders. Who is there on the traditional leaders? And this question, it can be for a further of 12 marks. So this is the compilation. So we are saying that number 1, provincial houses of traditional leaders were established in 6 provinces that have traditional leaders. That is the first now point. The second point, these regions, they are namely Eastern Cape, Free State, KwaZulu-Natal, Limpopo, Mpumalanga, and Northwest. So that is number 2. The national and provincial houses of traditional leaders enhance cooperative relationships within the national provincial government. So we are saying that there must be a good relationship between these governments. While establishing the local houses of traditional leaders, it deepens and cements the relationship between the municipalities and the traditional leaders on the customary law and the development of initiative. That is point number 4. And then to further explain in this, both the interim constitution, so interim, it is for the short time, it is in chapter 11, and the current constitution, chapter 12, they recognize the institution, status, and the role of traditional leadership according to customary law, the traditional leadership, local, provincial, and now the central government. All right. Remember, as we are tuning on, you need to understand the concept before you can even answer the questions pertaining. So we are saying the other point number 7, the national and the provincial legislation, they provide the establishment of houses of traditional leaders and the council of traditional leaders in the society. And it happens mainly on the informal sectors, informal settlement. And then we are saying the interim constitution makes provision for the establishment of a provincial house of traditional leaders in provinces where they are functioning authorities. Eastern Cape, KwaZulu-Natal, Free State, Mpumalanga, Limpopo, Northwest have a provincial houses of traditional leaders. The provincial house of traditional leaders function was to make proposal to the provincial legislator of the government in respect of matters relating to the traditional authorities, indigenous law, or the tradition custom of traditional communities in the specific province. So we are to see that here, in each and every province, in simple items, they have traditional laws which must be implemented and they must be followed. They must also be in line with the constitution. That is easy. And then we are saying, lastly, a provincial, a bill. Remember the word bill, we will discuss later. Have a bearing on the traditional authorities, indigenous law, or traditions and customs referred to the provincial houses of traditional leaders for comments and input by the Speaker of the provincial legislature. As the House was opposed to the bill, the provincial legislature did not pass the bill. So we are saying before the law, it can be a law, it can be taken to the constitution in terms of an act, it must be a bill. And under the bill, it must be proposed and debated first. And then when parties reach agreement, that is when it will be published, it will be a law, it will be an act or a legislation. That is for 8. Now, marks again. And then in 3.2, we are to say now, if ever we are seeing this particular concept, there is a question which we can see very well. And then it is explain why Gauteng, Western Cape, and Northern Cape provinces do not have the provincial houses of traditional leaders. The answer is simple. There are no formal traditional communities function in Gauteng, Western Cape, and Northern Cape. And 3.3, briefly explain the function of the Council of the Traditional Leaders in the Parliament. So we are saying that these traditional leaders, they've got what? A function where in the Parliament, which will now benefit the society as a whole. And the first aspect is that 3.3.1, advise and make recommendations to the national government with regards to any matter pertaining to traditional authorities, indigenous law, or the traditions and customs of traditional communities anywhere in the Republic. Number 2, advise the president on any matter of the national interest. And then 3.3.3, any parliamentary bill pertaining to the traditional authorities, indigenous law, the traditions and custom of the traditional communities must, after being passed by the house in which was introduced and before it was introduced in the other house of parliament, be referred to the council by the secretary to the parliament for comment, advice, and support, or the opposition. That is for 8 marks. So we are saying that the traditional leaders, they play a vital role in our community. All right. And then question 4, each province has its own independent regional government and has the authority to take its own decision. Name 9 provinces that are found in South Africa. That is an easy 9 marks. We've got Eastern Cape, Free State, Gauteng, KwaZulu-Natal, Limpopo, Mpumalanga, Northern Cape, Northwest, and Western Cape. 9 marks. Number 5, discuss 3 levels of government. So we are saying that how many government we have? We are metropolitan government, we are having the local government, and we are having a district local government. So we are saying the national constitution, according to the Act of 108 in 1996, explain 3 levels of government in chapter 3, articles 1 as follows. In the Republic, government is constituted as the national, provincial, and the local spheres of government, which are distinctive, interdependent, and interrelated. And then, if ever we are moving on, and let us see, now these are the types of government. So we are having the national government. It reports to the legislature, which is now the parliament. And then we are saying the parliament, it is having now the legislative power, which is to make laws for the whole country. And then we are saying that the executive position law for the whole country is the president, the deputy president, and the cabinet. They work hand in hand. And then we are having the executive powers and responsibilities. They develop national policy and implement national laws. Then we are having provincial government. So these are the provinces. So provincial legislature, they enact legislative powers. They make laws for the specific province based on the stipulated constitution powers to the provinces. So their power, it is limited only in the specific province. And then we are saying the executive positions is the premier or the MEC. They are responsible. And then the executive power and the responsibilities, they develop the provincial policy and implement provincial laws. We've got local And then we are saying the legislature is the municipal council, the legislative power. They make laws of the specific local authority according to the stipulated constitutional power. And then executive position, it is an executive committee. The executive powers and responsibility, they are responsible for the local matters like development and service provision to provide services like electricity and sanitation. That is for 15 marks. All right. And then if ever we are moving on, we are to see that the national government is known as the national state administration. This sphere is concerned with the administration process in the state departments. Then we are having provincial government. It focuses on the administrative process at the provincial governmental level. And then we are having the local government. It focuses on the administrative process at the local governmental level. So we are saying these three, they must work hand in hand. Then question 6, discuss the composition of the executive authority of the central level of the government. So we are saying that at the first point, the executive authority of the interim government rests with the president. That is the first point, who must perform the function responsibilities of the executive in accordance with bind according to the constitution. That is the second aspect. And then we are to learn that the cabinet consists of the president, deputy president, and ministers who are members of the parliament. That is the other point. And then the president may, however, in consultation with the deputy president and the leaders of the different parties of parliament. That is the other point. And then point number 5, they appoint not more than one minister from outside the parliament, so that it can be for a maximum of 10 marks. All right. Here, you can be asked to name 10 cabinet portfolios and the members. So what I want you to do is that it was for 2016. So you can check for the latest one. So what is going to change here are the or cabinet members. Keep on reshuffling and reshuffling, check who are holding the positions. But this one is correct. You can be asked to. So cabinet portfolio is the departments now. So we've got the ministers now. So we've got the Minister of Labor, the Minister of Communication, Minister of Economic Development, Minister of Public Works, Minister of Home Affairs, Minister of Rural Development and Reform, of Agriculture, of Health, Water and Sanitation and Corporation, Planning, Monitoring and Evaluation, Minister of Mineral Resource, Minister of Education and Training. And then we are to see that these are different ministers which are called cabinet portfolios. There are many. You can know 10 of these. And then we've got the Minister of Enterprise, the Defense and Military Veterans, Social Development, Telecommunication and Postal Service, Sciences and Technology, Justice and Correctional Service, Minister of Tourism, the Minister of Arts and Culture, the Minister of Trade and Industry, the Minister of Human Self-Settlement, of Basic Education, of Energy, of Sports and Recreation, the Minister now of Police, the Minister of State Security, Public Service, Transport, the Minister of Environmental Affairs, Minister of Women, Minister of Finance, and the Minister of Cooperative Government, Traditional Affairs. So these are the different cabinet portfolio. If ever we are moving on again, let us see that we go to number 7, which it can be asked a question to say, discuss the hierarchy of authority. So the hierarchy is from top to bottom of the central government level. So we are saying the hierarchy of government, it consists of, number 1, the legislative authority, they make law. Executive authority, they execute law. The judicial authority, these are the law adjudication or the arbitration. The courts have no the authority to settle disputes by applying or using the law through the South Africa, and that it can be for a maximum now of 9 marks. Okay, and then simply here we are having this schematic representation. So in this instinct, the following diagram explains the hierarchy of authority. So remember, I've said this is from top to bottom. So on the central government, it does not include the judicial function. So we are see that as it is addressed again in module 8. So let us have this one. So in the central government, we've got the administrative executive institution, which there is the highest now institution. So we are saying that it is subdivided into three. I've labeled it number one. So these ones, it is subdivided into legislative authority, executive authority. So I've labeled two. So you can see that under the legislative authority. So we are saying the legislating in terms of the laws of the country. We are saying the president must take or must account in that. And then we are saying the laws, it goes directly to the National Assembly and the National Council of Provinces. We are saying the National Assembly, these are the houses of now a parliament. So we are saying that there is 360 seats in the National Assembly. So we are saying that here we've got the National Council of Provinces, which are having 9 delegates. So one per each province. So the province will have 1 delegate. So you can see that I've written 1 per province. So there are 9 delegates. And then the cabinet consists of the president, the deputy president, and not more than 27 ministers. So these ministers, again, they will also emphasize power and authority where in the deputy ministers to do their job and their function. Remember, this is a line of authority. People are pressing each other by power. So we are saying that under this administrative executives give power and laws to the state departments and to the public protector. Therefore, we are saying that the public protector will ensure given power in terms of the Auditor General, the Human Rights Commission, the Commission of Gender Equality, and the IEC. He has the power to administer and to investigate fraudship in the country. Okay. And then if ever we had moved on, we would see that we must also understand that we need to study this concept and ensure that on our comment section, you are leaving the questions, and then you are commenting where you would not understand. And then if ever we are moving on again, we have to see that we've got some other important aspect of pieces of works which we need to complete before the end of this module. So you would see that we are having a question 8, whereby it says, discuss the principles of the cooperative government and the intergovernmental relation. So let us now see the question and try to understand correctly. And then if ever we are seeing that, we must see. And if ever we can see very well that we are having now provinces, they must be principled enough to cooperate, and the intergovernmental relations says there must be a positive relationship. And then this was at a chapter that all the spheres of the government and all organs with the state must, number one, preserve peace, national unity, and indivisibility of the republic, secure a well-being of the people of the republic, number two. And then the third aspect, to provide transparent, accountable, and a coherent government for the republic as the whole. And then the other one, be loyal to the constitution, the republic, and to its people. And then number 5, respect the constitutional status, institutions, powers, and functions of the government in other spheres. And then number 6, not assume any power or function except those conferred on them in terms of the constitution. And then the other one, number 7, is exercise their powers and perform the functions in a manner that does not encroach on the geographical, functional, or institutional integrity of the government in the other sphere. And then number 8, to cooperate with one another in the mutual and the good faith is for 60 marks. And then there's a sub-question just right there. And how do we mean by good faith? We mean by fostering friendly relation. Number 2, assisting and supporting one another. Number 3, informing one another of the consulting one on another on matters in common interest. And then to coordinate their actions and legislation with one another and adhering to agreed procedures and avoiding legal proceedings against one another. That is for 12 marks. And then number 2, by act on parliament. And then we are saying that they establish or provide for structures and institutions to promote and facilitate intergovernmental relations and to provide for appropriate mechanisms and procedures to facilitate settlement of governmental disputes. So these are the problems that they can arise. And then number 3, an organ of the state is the department of the state. It is involved in the intergovernmental dispute, must make every reasonable effort to settle the dispute by means of mechanisms and procedures provided for that purpose, and must exhaust all their other remedies before it approaches the court to resolve the dispute. So we are saying that if ever, an example, there can be a car accident, which is a state and the other state, they must resolve the dispute before they can approach the court of law. And then number 4, if a court is not satisfied that the requirements of the subsection 3 have not been met, it may refer to a dispute of the organ of a state being involved. Okay, and that one, it is for 12 marks. If we are moving on, question 9, it says discuss the values of the South African Constitution. So it stresses the human dignity and promotes of the human rights and freedom. Number 2, it eliminates the discrimination. Number 3, it entrenches the rules of law and the Constitution as the supreme law. And then the other one, it gives citizens the right to vote. It entrenches regular elections and multi-party system of the democratic government. So that is for 8 marks. And then if ever we are moving on again, and we are to see that we are having some of the other questions which they need our attention. And then in this instinct, we've got a question 6 of the South African Constitution. So what are the characteristics? Is that the Constitution is the supreme law, also over Parliament. Number 2, the Constitution provides a democratic system and equal voting opportunities for all citizens. Number 3, a Bill of Rights guarantees equal rights and protects the rights of all citizens of South Africa. The courts are independent and subject only to the Constitution and must apply law impartially without fear and favor or prejudice. And then the other aspect, there are 3 levels of government will cooperate but not interfere with one another. And then number 6, the 9 provinces replace the 4 former provinces, and then 10 homelands. And then the last aspect now, the diversity, which is the differences of all people, is recognized and ensured by means of recognition of 11 official languages, an electoral system of proportional representatives, 9 representative provinces in the parliament, the recognition traditional leaders and traditional law, and the protection of different rights and the enrichment of interest of the diverse community. So that is for 14 marks. If ever we are moving on again, we are to see that we are having now question 11, which it says discuss the concept interim government with the references of South Africa as an example. The word interim government, we are saying that our constitution is interim because of it keeps on changing. The preamble of the Constitution 200 of 1992 of South Africa explain the needs, the nature, and the interim government. Firstly, there was a need for a new order in South Africa in which all adults are entitled to a common South African citizenship. This did not exist before 1994 in a sovereignty and a democratic constitutional state. So remember that in the olden days, there was no democratic change. So secondly, the new order must be based on equality between men and women, which we know as affirmative action. So we are saying that between people of all races, and then so that everybody can enjoy and exercise their fundamental rights of freedom, which it is in the Constitution right now. And then we are talking about, thirdly, the preamble explains how these principles is to be implemented. Elected representative for all people in South Africa should be mandated to adopt the new constitution in the accordance with the pre-agreed constitutional principles. And then fourthly, while this process of drafting the final constitution is still in progress, provisions must be made for the continued government of South Africa based on the principles of the national unity and the restructuring of the existing government institutions. And then the last aspect, the continuing governance of the process based upon the principles of the national union, while the final constitution is being drafted by elected constitutional assembly, is known as the interim government. All right. And then that is the other point. So it can lead to 60 marks. The last now is that the interim constitution process, when in 27 April 1994, until the adoption of the new and the final Constitution Act of 108 of 1996, the interim constitution also provides a clear guidelines regarding the structure of the interim government. So you don't need to stress here. What is important is that you must know that in the previous, there was no rule of law and people were subjected to trash. So we are saying that after this law in 1994, the constitution, it keeps on changing and it is also keeping on changing now. That is the key concept. So that is why we are referring to the interim government. Ensure that you are hitting the subscription button and ensure that you are sharing to those who are concerned. At MATRIC+NATED Specialist, thank you very much for your time. And I hope to see you on the next video. Thank you very much.